Okay, Judge.
All right. For the record, we're now on YouTube. This proceeding is in public pursuant to constitutional and statutory provisions and requirements. Defense has demanded the right to a public forum. We cannot do a public courtroom because of the COVID pandemic. So, Mr. Freilich, the court will take judicial notice of the prior filings. I do not have such a memory that I could take judicial notice of matters that have occurred that I do not have a recollection of. But as far as the filings, yes, I note that this offense date allegedly is July the 12th of 2017. The actual information or complaint was filed July 13th of 2017. Anything else you want me to take specific judicial knowledge of?
Judge, just the assertion under, let's see, I believe there was a assertion of the right to speedy trial that was included on a motion dated January 23rd of 2019, where there's definitely an assertion on that. There was, let's see, let me address my motion. That's an assertion there, October 28th of 2020. There's a different assertion. On November 11th of 2020, there was a constitutional and statutory motion for speedy trial. There was a state not ready on, I'm not going sequentially, Judge, but there's a state not ready on August 14th, 2019. And again, my client has previously testified to his prejudice that he has suffered due to the delays in this case. So I'd like you to take judicial notice of his previous testimony.
Is this not an independent or separate motion, Mr. Freilich?
It is the same case, Judge. And as I'm sorry?
I understand that part. My question is, this is a separate and independent motion, is it not?
I believe that's a yes and a no, Judge. Due to the fact that my client has previously asserted his right to a trial, has previously requested a speedy trial on multiple occasions, I do believe that is relevant to that court. And because it's taken place in this case, because it's taken place in front of the same judge, you who heard those arguments, we believe that those are cumulative and should be taken into consideration. My client has put testimony on the record as to this issue before, so we're asking that you take judicial notice of that testimony. So where is an additional motion, I believe that motion is not independent, it is cumulative.
Well, then what I'm going to have to do is, obviously, because I hear all kinds of cases, I do not have a separate and independent recollection of the testimony. So before I rule, if you ask me to rule based on previous testimony alone, then I'm going to have to go back, get a transcript, review it, and then make a ruling. I won't be able to do that today. That's at your insistence. I don't have a problem with it, just so that you understand.
Right.
So is Mr. Uh, Uziel Munoz Cruz not going to testify today?
Can I have a motion? Can I have a minute to confer with my client, Judge?
You might want to do that. Patty, would you put him in breakout, please?
Yes, sir.
By the way, does the breakout, that is not placed on YouTube, is it?
No, sir.
Okay. Patty, when was the last hearing? What date?
I can look that up for you if you want.
That's what I'm asking.
Okay. November 23rd, 2020. However, Judge, it appears that you ruled on that on February 5th, 2021.
Hey, Judge, we're going to have my client testify. I don't know if he knows how to get back from a breakout room, though.
I think, Patty, can you bring him back in?
Yes, sir.
All righty, thank you. Mr. Munoz Cruz, would you please raise your right hand? You solemnly swear that in this proceeding, the information, responses that you submit are, will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You may put your hand down.
Thank you.
Mr. Munoz Cruz, there's several things I'm going to cover with you briefly.
Okay.
First one is that you always have the right to remain silent unless you waive that right. The right to remain silent means essentially you don't have to make any kind of statement. You don't have to answer questions. Do you understand you have that right?
Yes, sir.
And I'm informed that you're going to testify. That means you're willingly giving up that right?
Yes.
All right. I will note for the record that you did have a brief moment in what we call breakout on the computer to discuss this matter or whatever y'all discussed between you and your attorney.
Yes, Your Honor.
Also, the court will also make a note that we have placed this matter on YouTube. This hearing is in public. It is a motion alleging violation of speedy trial, right to a speedy trial. There's been previous filings and demands for a speedy trial. The last hearing on the motion was filed on 11/23/20. The court ruled on February 5th of 21 on that specific motion. Let's see. All right, Mr. Freilich.
Yes, sir.
It is your witness, but briefly, Mr. Edelman,
Yes, sir.
anything specific you want to address before we proceed?
Not at this time, sir.
Thank you. All right, Mr. Freilich, proceed.
Mr. Munoz Cruz, you are the same person who's charged with evading, is that correct?
Yes, sir.
And previously you testified that your memory of this event was hazy at best. Would you agree with me?
Yes.
And you and I have discussed this case a little
Yes.
bit.
Yes.
And you have a factual and rational understanding of the case against you, and we've talked about the facts and the law, correct?
Yes, sir.
And you have asked the court on previous occasions to give you a speedy trial. Would you agree with me?
Yes. Before.
And you want to waive a jury and go directly to the judge. Is that correct?
Yes, sir.
And what were some of the factors that led to that?
What? Well, they didn't do the trial
ask-
before.
Yeah, because you didn't have a trial before. Let me ask the question a little bit differently. You want to go forward with a bench trial because you want a trial as soon as possible. Is that right?
Yes, sir.
How long have you been sitting in jail?
About 6 months, maybe a little longer.
Okay. You have other cases pending though, right?
Yes, sir.
But you've been getting time on this case, right?
Yes, sir.
So you have been incarcerated on this case specifically, not just the other cases.
Yes, sir. Correct.
Some of the other things that we talked about for wanting it to go to trial sooner. Did you know things now that you didn't know before that you definitely want to make this case go to trial sooner?
Yes.
What did you learn about this case?
The cops arrested me. Like according to their timing or something, was like after the the chase. They had a speed chase, right? And they got me in a different location from where they started chasing the guys.
Okay. So
Okay.
we have good facts for us. That's correct. What else? What else do you know about the case that makes you want to go to trial sooner?
But the driver from that car is the little brother to the guy that shot me in this past June
Okay.
last year.
So you have had no contact with a witness in this case,
No, no,
and so
not at all.
let me ask. Yeah. So you haven't had contact.
No.
So whereas if this case had gone to trial sooner, you would have had contact with that witness. Is that correct?
Yes,
But because his brother shot you, you no longer have contact with a witness in this case.
I do not. According to what I heard from my mom, they're both on the run.
Okay. So even if we were to find the witness, Judge, um, even if we were to find the witness, Judge, Mr. Munoz Cruz, because of that delay,
Mm-hmm.
that witness would be unavailable to testify.
To my understanding, yes, sir.
And that delay has prejudiced you. Is that correct, Mr. Munoz Cruz?
Yes, sir.
Judge, we're going to pass the witness at this time.
Ms. Taylor,
Mr. Munoz Cruz, good morning.
Good morning. How you doing?
I'm well. How are you?
I'm okay. Thank you.
You were initially arrested for this offense on July 12th of 2017, correct?
Yes, sir.
And you were released from jail the following day, correct?
Somewhat, yes.
And you had your
Around
first court appearance on August 3rd of 2017, correct?
there. Yes.
And you had subsequent court appearances on October 3rd of 2017, then January 11th of 2018, then April 12th of 2018, then May 23rd of 2018, then July 26th of 2018. Is that correct?
Sounds about right. I don't have information in front of me, but yes.
So a year passed between your initial arrest and when you failed to appear on July 26th of 2018, correct?
Mm-hmm.
Now, in that year, did you assert a right to a speedy trial?
I don't remember that.
And you were represented by counsel?
Yes. Yes.
So then you failed to appear according to court records, and you were eventually apprehended on July 13th of 2018, correct?
Yes.
And then
How?
is there something you'd like to add?
Well, when that happened, I would like to add that I didn't intend to not show up to court. I missed the date. Okay, just for the record.
Thank you. At the time that you failed to appear, you were represented by counsel, correct?
Yes.
And when you realized that you had missed a court date, you turned yourself in as quickly as possible, correct?
Well, I got arrested. Yes, sir. I didn't turn
You got
myself in.
arrested 4 months after you failed to appear. Is that turning yourself in as quickly as possible?
It's not. It's not. But I would like to tell you something. I was finding my son for CPS at the time, I had to come from out of town every 2 weeks for my son. So I was I was scared to to get charges, right? Because I didn't show up to court. I didn't want to damage the stuff going on with CPS for my son that his mom turned him into the system. So I came back from out of town to fight him, and it was the dates were just it was being too much for me at the time. So it was just a dumb decision not to go up to the court and say I had missed the date.
So you deliberately avoided turning yourself in.
If that's the way you want to word it, sir.
That is the way I'm wording it, sir. Do you
Okay.
agree or do you disagree?
I disagree.
So you were apprehended on December 14th of 2018,
Mm-hmm.
released from jail shortly after, and then
Something like that.
had subsequent court dates of January 9th, February 8th, March
Okay.
19th, April 1st, June 4th of 2019. And eventually, your case was set for jury trial on August 14th of 2019, correct?
I believe so. Yes.
And then at the first jury trial, the state announced not ready. It was reset for January 29th of 2020, correct?
Yes.
And then at that court date, your counsel agreed to a reset, correct?
Correct.
Did you prevent your counsel from agreeing to that reset?
What do you mean? If
Did you
what?
oppose your counsel agreeing to that reset because of your desire for a trial?
Did I oppose it?
Yes.
No. I mean, no.
So you agreed to a reset,
Yes.
and then you agreed to another one on March 20th, correct?
Yeah. I mean, it got reset. I mean, yes.
And then shortly afterward, the pandemic occurred and closed the courts.
Okay. Uh huh.
Now, how long have you been incarcerated? Not incarcerated, confined at the county jail.
Since 6 months. Since let's see, I got shot in June. I was in the hospital for all of July. In August, I was, yeah, like August 23rd.
And even if this case is dismissed or goes to trial, you will continue to remain confined because of the 4 pending
No,
felony accusations.
I'm sorry, go ahead.
Even if this case is dismissed or goes to trial,
Hmm.
continue to be confined because of the 4 pending felony accusations against you. Isn't that correct?
Objection, Your Honor, relevance. He's held in custody on this case. The only relevant question is whether he's going to be held in custody on this particular case. Whether he has other cases is irrelevant to this particular constitutional proceeding.
It's relevant to the issue of prejudice in terms of confinement, because if the confinement is not strictly caused by this case,
I don't
then
see
you
how the
can't-
cases are.
Hold on,
Okay.
Mr. Munoz.
Okay.
Okay. Go ahead and finish, Mr. Edelman.
I think
Sorry.
you understand the thrust of my argument, sir.
And Judge, my specific objection is the relevance of if my client is being held on this case, then he will not be held on this case if this case is dismissed because his rights are being violated due to his continuing incarceration on this case. Then anything else is irrelevant. Whether he has a parole hold is irrelevant. Whether he has other felony cases is irrelevant. Whether he's going to be released and go to a hospital afterwards is irrelevant. Whether he's going to be released and go home and sleep in his own bed is irrelevant. The only relevant question is whether his constitutional rights are violated and not where he's going to be residing after this case is dismissed.
May I respond, Your Honor?
Yes, you may.
For this argument, defense counsel actually needs to demonstrate that Mr. Uziel Cruz is in fact being confined because of this case, and he hasn't done so. If he's being confined because of 4 other pending felony accusations, then the fact of his confinement is irrelevant to this instance.
So you're saying that if my client has other cases pending, then why not just dismiss it then, Judge? Why not continue his incarceration forever? It doesn't matter. He's going to stay in jail anyway. That's the argument is ridiculous on its face and frankly insulting, because if my client is incarcerated on this case, we have a motion on this case pending. Let's try this case. Let's get this case resolved. And the fact that he has other has no relevance.
Hey,
Who's
you're talking
waving?
about the
Who's
fact,
waving
last
papers?
I heard was the fact that
Okay. Do
you
you
were
have,
cut out because of the feedback on the earphones.
Sorry. Hey, Uziel.
Yes.
With your microphone. Every
Yes.
time it goes like this, we can't.
Okay. I'm sorry.
Thanks. Sorry, Kathleen. I don't know what me rubbing my finger on my lips is going to do to the record. I apologize.
all right. It's a novel issue. Let me think.
Judge, let me have one other argument in there.
Wait a minute. There's been an objection. I haven't ruled. I've been listening to both sides on the objection. Now give me a chance to think this objection over, unless you're withdrawing your objection.
No, I want to add one thing to my objection. The prejudice, Judge, is up to this date. My client has been prejudiced by his continued incarceration prior to this date. So the objection is it's not relevant what happens after in the future as to whether my client has been prejudiced in the past. My client has been prejudiced based on the delay in the past. We're not arguing that he is going to be continued incarcerated, so that would be a problem. But the prejudicial is the delay in this case, not whether he's going to be continued to be incarcerated.
All right. The objection itself is overruled on the basis that it does have some bearing on the issue of prejudice, although whether it is in fact prejudicial or not is not the issue. The question is, as far as the prejudice that is alleged, does this particular issue of other cases that he's being held on have some bearing? I would say it has some bearing. I'm not necessarily convinced that it does or not, but to me, I'm overruling that objection, leaving it in the record. But I don't necessarily agree with state on the specific issue, but I think it has perhaps even remotely, it does have some bearing on the issue of prejudice. So that specific objection is overruled. Now, Mr. Edelman.
Yes, sir.
You may continue. Still your witness.
Thank you, sir. Now, Mr. Uziel Cruz, when did you lose touch with the witness that you believe will be able to assist you in your case?
I've man, I mean, he went to prison and he came out of prison. I mean, I don't know what date or nothing like that, but I mean, I saw him a couple of times, and then that was it. I haven't. I mean, sometime before I got shot, for sure.
And is it fair to say that since you've been confined to the jail, you've had limited contact with any members of your social circle?
Yes.
Nothing further, Your Honor. Pass the witness.
Mr. Fraley. Are you frozen on us or are you there?
No, I'm thinking, Judge. I
Oh,
apologize.
okay. No problem. For a moment, I thought we'd lost you because these computers get a little squirrely on us.
I understand, Judge. Mr. Munoz Cruz, we do think that without laying out too much of the facts of the case, you are accused of being the passenger in a vehicle
Mhm.
where you jumped out of that vehicle,
Mhm.
and that vehicle continued without you
Mhm.
with the driver who is now the missing witness.
Exactly.
Is that correct?
Yes.
And without revealing the contents of that, the driver and you may or may not have had conversations prior to you jumping out that would be relevant and material to our defense. Is that correct?
Correct.
Again, I don't want to jump too far in the weeds of this one, but without that person who is the driver of the vehicle available to testify, you believe that our defense is weaker. Is that correct?
I do so.
And it's because of the delay in this case that person is no longer available to testify.
Exactly.
Nothing further, Your Honor.
Anything else, Mr. Edelman?
Not for this witness, sir.
And nothing further, Judge Frost.
I have a couple of questions for your witness, Mr. Fraley. What is the name of this witness? Mr. Munoz Cruz?
Raimundo
Raimundo what?
Rubalcaba.
Rubalcaba.
Would you like me to spell that for you, Judge?
Rubalcava?
R-A-V as in Victor. A-L-C-A-B-A.
V, not B. All right. Ruvalcava? Okay. Now, this thing was set for a jury trial a while back, right? We all know that. Ms. Garcia, does the record show that any subpoena was issued for this gentleman, the Raimundo Rubalcaba?
I'd have to ask the clerks, Judge. I don't have access to that.
Okay.
Can you give me a minute?
I can save you
What?
time with that, Judge, not from the defense.
All right. Anything else we got?
Not as far as testimony or evidence, Your Honor. except for obviously the
The argument?
affirmative.
Mr. Edelman, do you have any witnesses?
No, Your Honor.
Now, Mr. Freilich, I don't have a clear recollection of past testimony. My simple question would be, at this point, are you saying to the court that the essential prejudice of this case, besides the actual length of time being held, and I realize it's technically, he's being held for other cases, but that is a separate issue. He is being held for this case. Now, is the prejudice you're asserting today saying that the case is possibly weakened? We don't know that because we haven't tried it and haven't had full testimony. But are you saying that today the prejudice is the loss of essential or allegedly essential witness?
There's three different ones, Judge, that we are kind of asserting. One, obviously, any prejudice, yes, the loss of the witness makes it a 14th Amendment due process violation, Judge. Whereas we would have had this witness now that he has, and it's not necessarily, part of it is that we haven't found him and can't just call him any willy-nilly. But in the meantime, his brother has shot my client, which would make it, relying on his testimony for its truthfulness, the fact that his brother has now shot my client does kind of change the dynamic of, it's not simply like my friend's cell phone number and I can't call them up anymore. We believe that has definitely changed things insofar as we couldn't rely on him to tell the exact truth, even if he were to be. Whereas if this case had gone to trial back in 2019, or even in 2020, that might have been the case. Because of the delay, that witness and the nature of the witness has changed. The materiality of their testimony, the availability of the witness, where he is, the fact that, obviously, any charges pending against that witness for his role in shooting my client. There's a number of factors at play that would not have been factors before. And the
now,
nature.
when was your client shot? What was the date?
It was June 2020. Is that correct, Uziel?
Yes, June 18th.
Okay.
So, first argument is the witness, the availability. It creates a constitutional argument as to the prejudice my client has suffered, the due process, due process, meaning he can't get a fair trial because of that delay. Second, obviously, his incarceration in the past 6 months on this particular case has something to do with it, because he, obviously this evading case, I believe it's charged 2017 Class A misdemeanor. He's already served 6 months on this case, nearing the completion of the maximum, to be honest, Judge. He's already kind of bumping against the maximum in this case. And that obviously is a concern. Basically, that part of it. And just the fact that he's been incarcerated for 6 months is, of course, prejudice. And the third argument, of course, any prejudice he suffered due to the delay overall and his memory. That's the third different prejudice argument we have, is that his memory, my client's memory, may not be as strong as it would have been 4 years ago. And we did have previous testimony about his memory, how the shooting affected his memory. He and I have talked about this case. His memory is better, but still not all the way to where it was. There has been previous testimony from my client as to specific conversations that he's had that he remembered better at the time in 2017 than he would in 2021. All of those taken into consideration, Judge, it is the missing witness, it is the prejudice in the time elapsed, and it is the prejudice in that he has been incarcerated for that time. So to answer your question, 3 different forms of prejudice that we're alleging in this case, all having to do strongly in his favor for the speedy trial violation, Judge.
All right. I'm gonna, on this one, I'm gonna take it under advisement. I'm gonna want Kayleen a transcript of the previous hearing wherein the defendant testified. If you can get that to me as quickly as you can, so I can make a ruling. That will be in compliance with your request that I take under judicial, or to take judicial notice or knowledge of the file. If you will call me every Friday, Mr. Freilich,
Okay.
call me every Friday to remind me about this pending ruling, because the last time it got away from me somewhere, somehow, and I am embarrassed, but I accept responsibility that I did not rule for about 2.5 months. And I don't want that to happen again. You were going to say something?
I'm hesitating. If I could just think for just a moment, Judge.
No problem. Take all the time.
If I could have, I think that we just asked we'd ask that have some bearing as to the delay as well. If I could put that as politely and as respectfully as I possibly can.
I understand what you're saying. That's why I addressed it, because it is an embarrassment to the court. But, you know, I have never avoided responsibility from when I make a mistake. So I will consider it. And like I said, call me every Friday until I've got a ruling. Hopefully I can maybe even make it by this Friday. I'm putting a little stress on Ms. Rivera. So as soon as we've got the transcript, I'll read over it and go from there. Mr. Edelman, your response or argument that you want to put on the record, please.
Thank you for asking, Your Honor. I'd like to point out paragraph 3 of the defense's motion. The first sentence begins, "At no time during the pendency of this case has the case gone to trial." This is factually accurate. The next sentence is considerably more open to interpretation. Each time the case has been delayed, it has been delayed through the actions and inactions of the prosecuting attorney, the investigating agency, and the court. Now, there are certain...
A little hard time hearing you.
Because of the mask?
Maybe.
Hey,
I'll try to...
why don't we mute Uziel Muzio's, why don't we mute the defendant? That might help with the...
I'm doing it now.
In certain circumstances, the defense counsel's assertion contained within the motion is true. For instance, the delay caused by the court's failure to timely rule on the defense's motion. However, it also ignores substantial periods of time in which the defendant was complicit in the delay that he experienced. For example, the year-long delay between when he was arrested and when he first failed to appear. The 4-month delay caused by the defendant's failure to appear and his refusal to return to court. The subsequent delays from January of 2019 through his first trial setting in August of 2019. And then the 2 agreed resets that the defense counsel took in January and March of 2020. So that is a very interesting interpretation of that sequence of events, that the delay has been caused through the actions and inactions of the prosecuting attorney, the investigating agency, and the court. Similarly, the prejudice that the defendant has presumably suffered. Defense counsel and the defendant themselves have put on a cursory set of facts to demonstrate that they are not able to produce a witness who would be helpful to the defense. However, what they have not done is specified any of the efforts that they have taken in order to determine the current defendant's whereabouts. There are no investigators. There are no requests for investigators. There are no other witnesses who testified to the current whereabouts, known or unknown, of the defendant, except for Mr. Munoz Cruz, who himself has been confined for the past 6 months and presumably therefore does not have regular contact either in person or through any sort of media. So whether this defendant actually cannot be produced is a question that has not actually been determined by the defense for this court, and therefore for purposes of the prejudice determination, whether there is a missing witness is an issue that has actually not been established. Furthermore, whether the witness would be unhelpful to the defense on the basis of the witness's brother having shot the defendant is a matter of speculation. It might be true. It probably is true, but we don't actually know that it's true because we don't know anything about the relationship between the witness and the witness's brother. It's possible that the two have a deeply fractured relationship in which Mr. Rubalcaba would be happy to testify against his brother or testify in favor of Mr. Munoz Cruz. Whether those two are the same thing is a matter of interpretation. So defense counsel has not actually established that the witness cannot be produced. Defense counsel has not established that the witness, if the witness can be produced, would now be unhelpful to the defendant. Even if those two things were true, the defense counsel has not addressed the defendant's complicit conduct in his own delay. Furthermore, the defense counsel has not actually established that the defendant is being confined because of this case. Defendant has 4 other felony cases that he has accrued while he has awaited disposition of this case, and he is being held on all of them. So if there is pre-trial prejudice because of confinement or incarceration, it is not solely because of this case, but because of the other cases that Mr. Munoz Cruz has accrued over the course of the intervening 4 years. In defense counsel's motion, defense counsel stated, defendant has filed multiple motions asserting his right to a jury trial, including on January 23 of 2019. You may notice that subsequent to this assertion of the right to a jury trial on January 23, 2019, there were multiple resets spanning from January to August. And then after those cases actually were put on the jury trial docket, the defense counsel agreed to resets. It's a very strange interpretation of the assertion of the right to a speedy trial. Finally, while this case is entitled constitutional and statutory motion for speedy trial, in actuality, what it is a motion to dismiss. And when a party files a motion to dismiss for violation of speedy trial without actually demanding a speedy trial first, then the party needs to present cogent arguments why the party has not requested a speedy trial, but in fact requested dismissal. Under Cantu v. State, the request for a motion to dismiss for violation of speedy trial in the absence of prior assertions to the right to speedy trial is entitled to grave skepticism.
What's the site on
Because
that? What's the site on that?
Cantu v. State, Your Honor.
Yes, what is the site? Not
Give me a
just the
few
name.
moments, Your Honor. (253) Southwest 3rd, 273. I'll repeat that if you need me to, sir.
253 Southwest 3rd, 273.
Correct, sir.
All right. Continue if you have further.
And the court continues, whether and how a defendant asserts this right is closely related to the other three factors because the strength of his efforts will be shaped by them. The more serious the deprivation, the more likely a defendant is to complain. Therefore, the defendant's assertion of his speedy trial right or his failure to assert it is entitled to strong evidentiary weight in determining whether the defendant is being deprived of the right. Filing for a dismissal instead of a speedy trial will generally weaken a speedy trial claim because it shows a desire to have no trial instead of a speedy one. The failure to diligently seek a speedy trial supports the lawyer's adage, never tried, never convicted. That fundamentally is the crux of what defense counsel wants. He wants a dismissal, not a trial. If he wanted a trial, then one would assume that he actually would have diligently pursued it rather than delaying multiple times and failing to appear in the court's authority. So for those reasons, the motion should be denied.
All right. I will be pending or waiting for the transcript, and I will try and give you a ruling as quickly as I can thereafter.
Judge, if I may respond briefly.
You may.
I attached in the chat my client's second assertion of the right to a speedy trial to address Mr. Edmonds' last notes v. Cantu.
What was that date?
The second one, I believe, Judge, was October 28th, 2020. The first one was January 23rd, 2019. And I can read from the motion from January 23rd, 2019. It says specifically, furthermore, defendant asserts his right to a speedy trial as guaranteed by the Sixth Amendment of the United States Constitution, Article 1, Section 10 of the United States. Article 1, Section 10 of the Texas Constitution, and Article 1.05 of the Texas Code of Criminal. Defendant requests an immediate and speedy trial in the above entitled number cause. That is from my January 23rd, 2019 motion. And I just attached what's now being shown from October 28th, 2020 of, again, that's the second assertion of a right to a speedy trial, showing that my client indeed does want a speedy trial. In addition, Judge, during the hearing, which is going to be addressed by a subsequent motion, hypothetically, if we're talking about what could happen after this, we are going to have another motion asserting our right to a bench trial, which we are going to ask for at this time as well. But my client did testify as to that during the hearing, indicating he does indeed want a trial.
Your Honor.
I'm not Go ahead, Mr. Brady.
But even if we set aside that part of it, Judge, our specific argument is that even if he were provided a trial, and under one of the numerous reasons for prejudice, even if we do set aside our assertion, the length of the delay, the reason for the delay, Judge, and the prejudice, and I might have case law on this somewhere. I don't have it prepared because I wasn't prepared to make this argument until right now. The delay itself has to be taken in light of my client's incarceration in this charge for the past 6 months on a misdemeanor charge. As we all know, the further that we go into my client's incarceration, the less it matters as to whether or not he actually gets a trial. And by that I mean, once my client reaches a maximum sentence in this case, it becomes almost irrelevant as to whether or not he gets a trial because he would have already served that sentence. And I do believe that changes the nature of the delay and the prejudice for it. And let me explain as brief as I can. Once my client has reached his maximum sentence, he has served it whether he is guilty or not. And the fact that he's been incarcerated for 6 months and has requested a speedy trial, both on the record today, back in October, back in 2019, because he's been incarcerated on this charge for 6 months, that changes the fact that we need to have a trial sooner. Because once he reaches that maximum date of the nature of the charges, he's already served his sentence. The fact we've seen many clients take pleas based on the fact that they're going to serve the sentence anyway. We need to have a trial sooner in this case. And if we just look at that 6 month delay, that's enough to trigger the burden on the state. Just that 6 month delay, as Judge, you know from the case law, just a 6 month delay changes the nature of it to flip it on the state to have more of a burden. And the fact that my client has been incarcerated for 6 months completely changes the nature of the reason for the speedy trial while it's so necessary now. Is because at this point in time, Judge, that 6 month delay where he's been incarcerated is very close to reaching the fact that he's already done his sentence anyway. So we need to have a trial soon. Because we haven't, that's the violation. And as we go back to the original Barker-Wingo case, if we find there is a violation of the speedy trial right where we should have had it by now, the only remedy is a dismissal. And that's where we are at this case.
May I respond briefly, Your Honor?
Sure.
Defense counsel pointed to his motion asserting the right of speedy trial filed in October of 2022. What he fails to point out to the court is that he filed a subsequent motion, constitutional and statutory motion for speedy trial, which functions in the same way as this motion, in that it is called a constitutional and statutory motion for speedy trial, but its order actually gives it the function of a motion to dismiss. And that is the motion that was litigated in November of this past year, and the one the defense counsel did not urge the court to sign for 2.5 months. So now for the defense counsel to claim that it is diligently asserting its right to speedy trial when it allows the court to not sign a motion for 2.5 months strikes me as deeply disingenuous. Second of all, Mr. Munoz Cruz is
Judge, off the record for just a moment.
No, Mr. Edelman is in the middle of.
Judge, when he uses the word disingenuous, I take personal offense. I'd like to go off the record for just a moment.
No, sir. I heard the word, and I know what you're thinking. I'm not going to go off into a rabbit trail between you two guys. So I understand that you consider that, and I hear it as a sidebar.
No, Judge. I would like the opportunity to call an additional witness as to whether or not I had contacted the court and urged you to sign this motion, I believe we should go off the record for just a moment.
I will allow that when Mr. Edelman is finished with his point. I will allow you to speak off the record after that. Mr. Edelman, finish your point.
Additionally, Your Honor, while Mr. Munoz Cruz has been confined, he has not been confined because of this case. He has been confined and he has had this case pending, but he has been confined because of the felony accusations that he has accrued over the years and his failure to abide by the court's requirements, for example, to show up. So the fact of his confinement is not immediately attributable to this case. And furthermore, this isn't a misdemeanor with a 1 year range of punishment, which means that despite the fact that he has been confined for nearly 6 months, he's nowhere near the maximum. So
I understand evading
Mr.
class A, yes.
Mr. Freilich's argument would be considerably more convincing if it were actually correct, but it's not.
All right. Anything else, Mr. Edelman?
No, sir.
All right. Mr. Freilich, we are now off the record. Ms. Rivera? By the way, since we're off the record, I will tell you both and tell the world. The responsibility for the 2.5 month delay between the November 23rd hearing and my ruling on February the 5th is not the responsibility of the defense counsel or the defendant, it is mine. As far as I'm concerned, defense did everything they were required to do when they presented the motion and requested, or obviously expected a ruling on the part of the court.
May I interject briefly,
That's
Your
my
Honor?
responsibility. Pardon me?
May I interject briefly, Your Honor?
If you choose to.
I will only do so with the court's permission.
You have my permission. We're off the record. Go ahead.
I believe my emotions got away from me and I mischaracterized the defense counsel's actions. I should not have referred to him as disingenuous in his argument, and I apologize.
Very good.
Yeah, we're good, Andrew. No,
Mr.
good.
Freeling.
Judge, the only thing I wanted to point out in regards to that, I'll just withdraw it. I mean, it's not, we're going to, yeah, we're good. That's neither here nor there. I don't think that's going to make or break any arguments or any rulings by you. So we're good.
No, sir. Well, anything else you want to add?
No, we're good.
All right. So you guys, you're both very professionals. Keep it that way. Mr. Edelman, I respect the fact that you recognized your description as possibly, or I'll say it outright, was inappropriate under the circumstances. Mine is the fault on that ruling, nobody else's. So, anything else we want to do on the record? Very good. Ms. Loretta, if you'll get me my, yes, ma'am.
Is it the November 23rd transcript that you need?
I'm sorry?
Is it the transcript from November 23rd that you need?
I believe that's the one we're referring to, Mr. Freilich.
Yeah.
He asked me to take judicial notice of his previous testimony.
Yeah. If that's the day that it was. Kathleen, do you, I'm sorry, Kenny, do you have the, I don't know that it was November 23rd. I know that there was a hearing on this case for a speedy trial in November, late November, and that would be the one.
All right.
I just need to know the date.
Ms. Loretta, just review it, look back on this particular defendant and see if there was a hearing, the last hearing that was had at which Mr. Munoz Cruz testified?
Well, my records don't go by defendant. The date is my thing, and I mean, I will review the hearing from November 23rd, and if that wasn't the date of the testimony, then it would just be going day by day to see which one it was. But I'll just start with that, and
Well,
if
get with
that
Patty.
looks like the one, then I'll just go with that.
Get with Patty. She can give you the dates when we had hearings.
I have November 12th as one of them potentially. I have January 15th, but that's not going to be it. I think it's the November 12th. And there's a November 23rd. And no, it's not November 12th. It's the November 12th was reset for November 23rd.
All right. So probably November 23rd is a fairly good date. Okay. Anything else for me about anybody? All
Are we
right.
opening up to other? No, nothing else.
All righty. Then that'll conclude this hearing at this time. The response from the court will be pending.